It is premised on the notion that somehow like all children's court hearings, there is an assumption afoot that there is something in the nature of the children's court hearing itself, as well as what flows from it. I'm not so much thinking of, the punishments that flow from it, but certainly the connections to service that flow from appearing before a children's court, that there is something that will result in there'll be a positive outcome. And the literature over the years has always placed a lot of emphasis on something being quote-unquote magical or very therapeutic, if you like, about appearing before a court and the relationship that might be developed in a relatively short hearing between the magistrate and the defendant. Now, I'm not sure that there's much to that, in my view, but it's certainly true in the case of the Children's Koori Court that the kids who appear before the court and are other than found innocent or otherwise acquitted, that they are invariably connected to various programs and services that they may not otherwise have been connected to, and it's perhaps those services rather than the experience of the court that has the most beneficial effect. As to the type of court it is, how we conceptualise it, some people say it's a specialty court, some people say it's a specialist court. It is not a traditional therapeutic jurisprudence type court insofar as there is not ongoing case management, therapeutic courts, courts informed by therapeutic jurisprudence notions are very much oriented toward addressing the needs of defendants, connecting them to services, and where the presiding magistrate almost has a case management role where the cases come back periodically for review. The Children's Koori Court does connect kids to services, but other than adjournment for the purposes of case planning, there really is no ongoing involvement. So it's not a therapeutic problem-solving court really in that sense. Marchetti and Daly, who have probably written more than anyone else on Indigenous courts in Australia, see it as different from both specialist and specialty courts because they argue fundamentally that there is no other courts where dealing with the tensions and problems and challenges between white Australia and Indigenous Australia, where that is a salient consideration behind the court. In other words, that improving those relationships is a factor that's animating the court. That's why they essentially say that these courts are in a category, Indigenous courts are in a category of their own. The courts are quite intentionally informal, and this is true of all Indigenous courts. And I guess the other thing I would say, and it will become evident, they are low volume courts. In other words, the number of kids who are processed through the Children's Koori Court of Victoria is quite small, in large measure because the Indigenous community in Victoria is quite small. Nevertheless, the Aboriginal kids are disproportionately represented, albeit the absolute number being very small, they're nevertheless disproportionately represented in the Victorian juvenile justice system. If you go into the Children's Koori Court, you will find that a magistrate who is the sole sentencing authority sits with usually a male and a female elder or respected person. The hearing is heard around an oval bar table. The courtroom itself has Aboriginal artwork in it. It has Aboriginal Torres Strait Islander and Australian flags in it. It has a lot of Indigenous artwork around the walls. The other hearing participants include a police prosecutor who's uniformed and intentionally so. There is a Victorian Aboriginal Service lawyer, usually in attendance, Children's Koori Court worker, a youth justice worker from the Department of Human Services who is often Koori, him or herself, or if not, they come from there is a section within the Department of Human Services where that focuses on Koori youth. The defendant appears, often a family member or some other significant person in their life will appear. A professional may appear in the court, such as disability services worker where it's relevant. And perhaps a metre behind the table is the public gallery. And in the public gallery you'll find anyone who wants to come in, because it's an open court, although you're not allowed to report proceedings or identify anybody. And sometimes you'll find members of the Aboriginal community will come along, and you will find representatives of community service agencies sitting no further from the oval table than Peter is sitting from me. The hearings, unlike the mainstream children's courts, go from about 25 minutes to almost 2 hours. The average is close to an hour. In a mainstream children's court, the cases can be dealt with in a matter of minutes. It sits only one Thursday morning every second week, and the number of cases that are heard during that morning might be only 2 or 3. So it is a low volume court. The goals of the Children's Koori Court are, as mentioned, not only to reduce overrepresentation, but also to increase Indigenous ownership of the administration of the law, which begs the question, what do these actually mean a little more operationally? The objectives that flow from the first goal is to reduce the failure to appear rate. In other words, kids who are summoned before court, in many instances, they don't bother turning up. The aim of the Children's Koori Court is to try to ensure that they do turn up. It's also to reduce the court order breach rate, so if a child is placed on probation by a court, that order is actually adhered to. I don't know what the situation is in other states and territories, but if a court order is breached in Victoria, then the child comes back to the court, to that very same court in which where the order was made. So the aim is to reduce that court order breach rate. It's also to reduce recidivism, the rate of offending, but not only the rate of offending, but also the seriousness of any further reoffending that might take place. Another objective is to build a culturally responsive juvenile justice system on the assumption that if it is culturally responsive, whatever that means, and we'll come to that, that in and of itself would mean that it might lead to less reoffending. The second goal, which is increasing Indigenous ownership of the administration of the law, in terms of objectives, it's thought that if the Aboriginal community engages with the Children's Koori Court more positively, then that would be one dimension of increased ownership. Another one would be that if the Koori community really is involved in the whole process of taking its own children, holding them accountable for their behaviour, that would also reflect increased Indigenous ownership of the administration of law. And lastly, if that community itself made both the community standards or codes of conduct as well as general codes of acceptable conduct understood and promoted, that would also be a reflection of the ownership of the administration of law. This framework is how the Children's Koori Court was documented, was conceptualised rather, by that reference group. In other words, those who conceived of the court and documented it. What were the evaluation questions? Well, the first one was an outcome evaluation question that sought to answer, well, have these various objectives, these 6 objectives that I just shared with you, have they been realised? There was a process dimension to the evaluation, the first one of which was, does the Children's Koori Court serve its client group, its target population? Another process evaluation question was, well, was it actually implemented in accordance with its design? Because the design was reasonably carefully set down, but did it actually operate as intended? And the last one was, of the process evaluation questions, is how do the court actors, which means the magistrates, the lawyers and the prosecutors, as well as the defendants and their families, how do they experience the Children's Koori Court? And lastly, the whole evaluation was formative in its intent. In other words, the aim was to look at ways of trying to improve the operation of the Children's Koori Court. In the fourth question, I've got defendants and their families both in bold and in parentheses, because it proved impossible to carry out that part of the study. And this year we're going to have another go at doing that, and I'll share with you, time permitting, some of the challenges involved in actually carrying out this study.